Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, joined today by Maynard Nexsen attorneys Jennie and Fay Edwards. Good to see you both.
It's good to see you.
Well, today we're going to be digging into the Supreme Court. We've got our resident SCOTUS nerd in the building. We're so excited to have you here. We're going to talk about a couple of employment-related cases, and we're going to analyze them a little bit. But we were all together recently and did a deep dive on the impact of E.M.D versus the Ohio Department of Youth Services, and that's where the Supreme Court issued a landmark ruling on reverse discrimination. However, there have been a few other Supreme Court cases this year that have also impacted employers. So, Fay, let's talk about Trump versus Casa, where the court significantly limited the ability of federal district courts to issue broad nationwide injunctions. How might that affect employers?
So first, let's give a background to understand the case and the severity. So the Trump administration signed an executive order 14160, which identifies circumstances in which a person born in the United States is not an American citizen. So advocacy groups and organizations sued the federal government and to prevent the executive orders from being enforced. So from there, the federal government sought an emergency relief from the United States Supreme Court, and to ask this one question of whether those injunctions, the preliminary injunctions that the district courts invoked on all jurisdictions, does it meet outside the scope of what Congress has set out for these district judges and jurisdictions under the Judiciary Act of 1789? So in sense, whether an injunction's application to non-parties exceed the authority Congress gave the federal courts through the act. And the Supreme Court said, yes, it exceeds its scope. And essentially that any preliminary injunction that a court sets in response to an executive order is beyond the scope of what Congress initially stabled or gave as a relief. And so essentially a plaintiff or multiple plaintiffs that have brought a case against, say, the federal government in this situation due to an executive order can no longer just say that no one or the executive order does not go into effect for anybody, including the plaintiffs as well as non-party members. And so essentially, this was a win for the administration that allows executive orders, when they are set, they can immediately be enforced. To answer your question, what does this mean for employers? Well, that gives some guidance on when you see an executive order being put into place, it's immediately enforced. At first, before this case, employers were wondering, should they immediately act on it to be up to code to what the executive order initially stated? Because oftentimes an injunction would be in place. This time, it just sets in stone that there cannot be an injunction at this point, that executive orders, once they are enforced, employers ideally should immediately come into compliance underneath it.
So, Fay, what does this mean for multi-state employers and their compliance obligations when lawsuits are filed? Because, of course, a nationwide injunction is much different than an injunction that is limited in scope and geography.
Right. So again, it go back to immediately they need to invoke or enforce whatever the executive order says. But interestingly, the Supreme Court did not address class actions. And so as a litigation strategy, plaintiffs' attorneys will likely have a class action formed similar to a nationwide injunction. It has the same effect, essentially. So if a plaintiff that has the same injuries as others, potentially 50 or 100 more, it can have the same effect when the court says, okay, immediately stop what you're doing until we address the merits. So in that situation, for employers, if there is a class action brought against them, potentially a court could have the same effect by issuing an injunction then. It just depends. And until the court addresses that issue, then there's going to be a lot more plaintiffs bringing class actions than usual. But other than that, just multiple jurisdiction or multiple state employers should just be prepared to immediately respond when an executive order requires you to make some adjustments within your employment settings.
The class action angle is interesting and will create some interesting jurisdictional and venue issues and disputes. I imagine.
Precisely.
Okay, well, switching gears to another case. In Stanley versus the city of Sanford, the court narrowed the scope of post-employment ADA claims. So what's this mean for employers that are managing retirement benefits, disability-related disputes, or post-termination communications?
So in this case, a former employee who had taken disability retirement found out that her health insurance at that time, the policy that she initially understood it to be when she first started her employment, had changed from first receiving free insurance to now only receiving insurance for 24 months upon retirement and receiving it due to disability. So that employee sued her employer, claiming that the reduction in the benefit violated the ADA because it discriminated against her as a retiree with disability. And so the court heard and considered who can bring an ADA disability discrimination case in retirement benefits and when. And the court ruled that a former employee cannot prevail on claims under the ADA unless they can plead and prove that they held or desired a job and could perform its essential functions with or without reasonable accommodations at the time of the employer's alleged act of disability-based discrimination. So many people are assuming that, okay, if you're a retiree, then that means you will likely lose in the case if you are asserting ADA discrimination. And the Supreme Court says that's actually not true. In fact, if an employee, a former employee, can plead and prove that they were both disabled and qualified when their employer adopted a discriminatory retirement benefit policy, then the Supreme Court said it's actually almost promising. So retirees can still assert ADA discrimination if a policy has been changed, but they just would have to have a little bit more proof to assert it, that they were qualified and were at the time they were discriminated before they, I guess when the policy was changed as a result. And so essentially what employers, in this case, it was a big win. While this ruling was significantly restricting who can bring it and when a person can bring the ADA claim, the court made it clear that such claims can prevail under certain circumstances, even if the plaintiff is retired or no longer employed at the time that they first filed the suit. And then as well as, I think employers should take away that they have to be really, really careful when they do change or eliminate certain benefits and provisions to make sure that they're not implicitly discriminating against retirees who are retiring due to disability. So they just have to be really, really careful before they make any changes in their policy.
So, Fay, then the applicable time period, if I'm understanding correctly, that the court was looking at was the date that the employer changed the policy, changed the benefit, and potentially eligibility for the benefit or the details of the benefit. It wasn't the date that the individual necessarily separated from employment.
Correct. Exactly. And again, you want to make sure that when a change is made and that you're anticipating any sort of employee taking retirement due to disability, make sure you're covering your bases to ensure that those individuals won't allege or assume that you're discriminating against them for a disability.
It's very interesting. So let's discuss now the E.M.D. Sales versus Carrera decision that clarified that employers only need to meet a preponderance of the evidence standard when defending FLSA exemption classifications. And this is an area that's often litigated in the labor and employment law arena. How does this change, this change in the evidentiary standard, how does it change the litigation landscape for wage and hour disputes?
Quite honestly, it doesn't change for too many. If anything, this changes within the Fourth Circuit and the states that are encompassed under the Fourth Circuit. So just a little background. Employees sued their employer, alleging violation of the FLSA's overtime provision. And the employer stated that these individuals are sole representatives and were exempt from their overtime pay as outside salesmen under the FLSA. The district court ruled in favor of the employees, finding that the employer failed to prove their exemption by clear and convincing evidence, which is a high standard. If we're looking at a chart, there's 3 evidentiary standards, and clear and convincing is honestly the second level and the second tier. Preponderance of the evidence is at the bottom. The third is beyond a reasonable doubt. And so in this situation, the district court said that they haven't met their burden on the second tier, which is the clear and convincing. And the Fourth Circuit upheld that same decision. So the Supreme Court essentially addressed, well, what is the standard? And they said that the standard is going to be a lesser standard, which is the preponderance of the evidence, which essentially the employer just needs to show like 50% that the person is likely to have done or is said employee classification. And so with that, it just is a shakeup for the Fourth Circuit and the states that are in it, such as South Carolina, North Carolina, West Virginia, and Maryland. Because they had a higher standard, evidentiary standard, they're going to now have to analyze it in a lower standard. And again, for employers, this is a win. They no longer have to show in the Fourth Circuit, at least, that an individual is without a doubt that they are an exempt employee. Now they can just show that they're likely more so an exempt employee versus 100%. But that doesn't mean it's not like a get out of jail free card. You still want to make sure as an employer that you're not misclassifying the employee. Before anything, make sure that they are supposed to be exempt or non-exempt. And then if they are non-exempt, make sure that you're following the guidelines within the FLSA before we get to litigation.
Well, and there can be a couple of oftentimes there are close calls under the FLSA for who actually meets the FLSA standards for exemption. And when we talk about exemption, of course, we're talking about individuals who are not subject to the FLSA's overtime and record-keeping provisions. Mm-hmm. So for employers who are having trouble making that call, the preponderance of evidence standard is definitely much more favorable than clear and convincing.
Yep, exactly.
So overall, how do you see these rulings impacting employers overall? Are we seeing more of an employer-friendly atmosphere for the Supreme Court and federal level?
So looking at what the Supreme Court did last year and over the years, it does seem like the Supreme Court is favoring the employer more. I'm interested to see. It's October. That means the Supreme Court is about to start back up again. If I had to anticipate anything, that any other employment decisions coming from the Supreme Court will be really interesting, and see if they do keep up with this trend of leaning towards employer more friendly regulation and rulings and opinions. But we'll just have to see. And I can't wait to come back to disclose more information and see if we are right with that prediction.
Fay, just to clarify for our audience, in the Trump versus Casa case, the holding was not that the court couldn't ever issue injunctive relief as to an executive order, but that such relief could not be nationwide. Is that correct?
That's correct. So essentially, the plaintiffs that bring the case, an injunctive order can be released or given for them. But anybody that feels or identifies with the plaintiff party but it's not in the case, it does not apply to you. It will not apply to them.
Understood. So the injunctive relief can still issue, but much, much more limited now.
Correct.
Understood. Okay. And then also, by way of follow-up question in the same case, that holding on the inability of a district court to issue nationwide injunctive relief, was that limited to the context of executive orders specifically, or did it? Bleh. Okay, let me start that over. By way of another follow-up question on the Trump versus Casa case, was that holding limited to the context of district courts and their ability to issue nationwide injunctive relief as to executive orders only, or did the opinion go beyond that?
So the opinion only talks about the executive orders. So we can go ahead and assume that it only applies to executive orders. For instance, they didn't talk about injunctions applying to agency decisions. For that reason, is widely still applied and can be used, and that can be used as a available remedy. So yes, only to the executive orders.
Understood. And we frequently see the Supreme Court liking that approach, where they very much cabin their decision in to one particular context and leave other issues, potential issues, for later.
Right.
Well, thank you, ladies, both for your perspectives on the Supreme Court and federal cases today.
Thank you.
Appreciate your time, Fay and Jennie, and we will see you next time on Work This Way.